All right, we're back on the record here. We've had a brief, in chambers, for lack of a better word, discussion. Ms. Cook had offered to call the daughter as a rebuttal witness as to the testimony from Ms. Niekamp. There was an offer of proof, essentially, that was made by Ms. Cook as to, I guess maybe it would go to the defendant's drinking patterns at the time of the parties separated in 2010, 2011, that there was also going to be some testimony as to why she left the defendant's home when she was 15, 16 years of age. We had a discussion about, I offered my opinion that it wasn't really that relevant as to fault of the breakdown of the marriage relationship. We did a brief recap of what I believe the testimony from both Ms. Niekamp and Mr. Niekamp established, but basically Ms. Niekamp was sober for a period of time during the marriage, that she started to drink up to a couple years before the separation. That I basically found Mr. Niekamp's testimony as accurate, that that she was going to AA, that she was trying to stop, she'd stop, she'd start drinking, he was going to Al-Anon, and the drinking was getting to be a problem. And that was kind of his reason why they separated in the first place. So we had that discussion, and at this point, I would turn to you, Ms. Cook, and certainly you're welcome to call the daughter to testify if you think that her testimony is relevant as to fault in the breakdown of this marriage.
Thank you. Your Honor, my client's indicated that he does not want me to call Erica Niekamp, and so we will not do that. We will rest at this time.
All right. All right, so I'm going to take the matter under advisement, and I'll issue a written opinion.
Thank you, Your Honor.
Does the court want to hear closing arguments?
I really don't.
Okay. I would ask, I know that the court has told me that because my trial brief was late, and I accept that, but we have cited case law in that trial brief that I think is very relevant. So would you consider that as my closing statement, since we clearly didn't get it to the court in time? And again, I apologize for that, because otherwise I think it's important for the court to know the case law that applies, we feel, and how that would apply.
The court is going to apply the appropriate case law to the facts and circumstances of this case, whether it's provided by one of the parties' trial briefs or not. So I'm not bound by the law that the parties submit to the court, and I will make a decision based on the law that applies to these facts. The cases that you cite are similar to the cases, if not identical, to the cases that Mr. Greer cited in his trial brief as well.
And I understand that, Your Honor. I'm not questioning that.
Okay, go ahead and make your closing argument.
Your Honor, I'm really not arguing. I'm just asking if you'll consider my trial.
Your Honor, I don't have any objection if you consider the cases she cited. I'm very aware of the court and how the court handles these cases. The court thoroughly researches every avenue that it can, probably more so than the lawyers. I'm comfortable with if the court wants to look at her brief, the court can look at her brief. The only dispute that we have is that she indicated that she drank more than we say she did. Other than that, I don't care. Consider the brief and the case law. It's fine. It's pretty much the same case law I cited.
Ms. Cook definitely wants to make a closing argument, so go ahead.
Sir, all I'm asking the court is that you consider the argument we had in our trial brief, and I don't need to make a closing statement then. And if you don't want to do that, that's okay. Then I feel I probably need to make a closing statement.
I'm offering you a closing statement. Now is your chance to make it.
All right. Thank you, Your Honor. I guess what I would state to the court is, I know you've heard all the evidence, and I know that this court is pretty diligent about the research that you do. I've seen that in other cases I've had with you. I think that what I want to indicate to the court that's very important is the very words that were stated by Ms. Niekamp, in which it was their intent to live separately from 2011 on when they separated. That there was not intent for them to get back together, to reconcile, and outside of the fact that she lost housing, they would have had no reason to even be in the same space. So I think that that's very important, because that's what the case law talks about, is the intent that they are not going to, that they're going to live separate lives. The evidence demonstrated they were living very separate lives. And I think it's incredibly important that my client has already paid over $60,000 to Ms. Niekamp, that even though they were separated, he did, and he didn't have to do, there was no order, while Ms. Niekamp did not offer any contribution back since 2011. And that's why I'm asking the court to consider those things and the facts that came up. Again, I know the court will review the case law. In settlement conferences, you have given me some indication of some things that you've been reviewing. But again, I'd ask the court to look at Byington versus Byington. That's 224 Mish App 103 and 97 case. I'd ask the court to look at Thompson versus Thompson, which talks to us about valuation dates. That's 189 Mish App 197. I would ask the court to look at the Ackerman case, which is 163 Mish App 796. That talks to the court that you have to apportion the marital estate, but you do not have to give a mathematically equal share. Of course, the Sparks factors are relevant at 440 Mish 141. That's 158 through 160. I know the court knows those factors intimately. The Knowles case, that's 185 Mish App 497. That's a 1990 case. And we attached to our trial brief an unpublished decision, which I know is not precedential, but the court can review based upon the facts. Jacobson versus Jacobson, that's a Mish App case, 1999. I would ask the court to consider it. Again, I understand that's not binding on the court, but it gives us law that I think is very important, which is, again, that the court can consider the party's intent to live apart and lead separate lives, and therefore not give any value to what has accumulated after the point in time in which they've separated, based upon the lack of contribution. So I just wanted to be clear with the court that those are cases I'd ask you to look at and consider. I know, again, you do a lot of research, and I'd ask you to consider the valuation date that we have. We can't go back beyond 2016. And I think you asked me a question, I don't know if it was on the record or not, but it had to do with what the valuation date is. I can't get you back to 2011 even if I wanted to. So I would ask the court to take a look at that 2016 value that we offered at the point in time that that was transferred over from plan to plan. I think that that is probably going to be the only number I can give to the court as a baseline. And I'd ask you to utilize that as what the value is that you would be dividing between the parties, and also ask you to consider fault in the breakdown of this marriage. Thank you.
Mr. Gurr, did you want to make any closing arguments?
Your Honor, real briefly, if I may, you know, I found both parties to be as honest as they could be, based on the fact that this is such a long-term relationship. I think the thing that needs to be considered is that this is an equitable court. To leave my client while she was married, and both parties had decisions, and they could have ended the marriage, and they didn't, to a very little portion of a retirement account is not fair. It's not equitable. It can't even be considered equitable. To consider fault, I think the court is aware that fault is not something that they really hang their hat on. And I would ask the court to consider one thing. Mr. Nightcamp indicated that he was going to Al-Anon for a while she was going to AA. He knew that there was a problem, yet he chose to leave these children, and I'm putting her child in it as well, because he's been with that child for almost all of her life. He chose to leave her with these children. Seems to me that maybe it wasn't as big a fault as it should have been. If it was such a big problem to end this marriage that he would leave those children with her, then she could not have been that dangerous. And I think the court needs to look at that. The other thing, Your Honor, is that my client is 55 years old. Her chance of making any sort of a retirement are a lot slimmer than what Mr. Nightcamp's are. One way I like to look at these divorces when we're done is, who would I rather be? You know, the plaintiff or the defendant? And I think the court, if the court takes a look at the facts and the circumstances of this situation, it certainly has to favor Mr. Nightcamp. He's making almost $100,000 a year. My client is shopping for people and delivering the groceries, and had a pretty good year at $30,000, not including her expenses. I think that it speaks volumes. This rebuttal witness, who was so angry at her mother for everything that she has done through this alcoholism.
I'm going to object because those are facts, not evidence. We didn't have her testify.
Sustained.
All right, I'll let that go. My point is that this is a situation, Your Honor, where an equitable decision needs to be made. The court needs to consider the Sparks factors, and many of them favor my client. My client is in no way, shape, or form ever going to be in the situation that her husband is. They chose 20 years together, and the court has to take that into consideration. We're not asking for alimony. We're just asking for an equitable division of that pension. Thank you.
All right, thank you. That's all for today.
Thank you.